All right. This is Steve Ross with a somewhat overdue video lecture on the Smith case and the Hobby Lobby case. What a fascinating, complicated mix of considerations go on in these cases. Um, let's start with Smith, which be where this section would end. There were no really interesting free expression of religion cases after Smith for quite some time. But this is to get ahead of the story. Smith is now a kind of a shot fired across the bow in this long, interesting story. And where we are now, obviously, very, very timely, very important. The Hobby Lobby case is a Affordable Care Act case, or we can equally well call it an Obamacare case. Um, Bound to happen that employers with religious objections might object to some of the health care provisions that they're required to provide. We'll get to that. First, Smith. Okay, what's going on in this case? What are the facts of the case, as the professors always say in a law school movie? Two Native Americans are challenging Oregon law, which prescribes the use of peyote. Peyote, for some of you in my audience who may not know this, is a hallucinogenic. It's made from natural substances, an extract of certain cactuses. It's been in use by inhabitants of North America since before the Europeans ever arrived here. Mystical medicine men, witch doctors, so called, in Mexico and Central America, and the Native Americans in what is now the southwestern part of the United States used peyote as part of their ceremonies to induce, visions and insights. It is a substance that's used in the making of a hallucinogenic called mescaline. All of these are somewhat similar to LSD. They don't render you violent, but they do generate, tremendously unorthodox and intense stream of mental representations in the taker. All right. These Native Americans are using have ingested peyote. Peyote is, no one denies this, a part of certain ceremonies that the Native Americans engage in when entering into certain kinds of religious rituals. All right. Oregon does not have an exemption for the religious use of peyote. And that's what the Native Americans are asking for. They're not saying that peyote should be legal for all, that the state doesn't have a reasonable interest in regulating the use of peyote among its citizens. They ask only a religious exemption seems the right way to go. And given what we have from the Sherbert and the Yoder case, they could reasonably think we're going to take this Oregon state law to court and argue that. Well, Oregon, again, you see this in the Yoder case. Oregon surely has a reasonable or even compelling interest. It's not obvious that it's pursuing that interest by the most narrowly tailored means. They fully expect that the court will subject the law to strict scrutiny. And then when they do that, they expect or they hope that the court will find that Oregon could make an exception for religious use, and thereby find this law unconstitutional. A lot of complicated things going on in this case, and I'll mention them in no particular order. First, the very astute among you may have noticed, why aren't these Native Americans facing criminal prosecution? Why aren't they facing jail time? They've admitted they've done something illegal, and it's certainly the case. If these were non-Native Americans, they probably would. If not facing jail time, they'd be facing a criminal prosecution. They might get off with, a lesser charge and a fine and probation, but there's no criminal prosecution on offer here. Why? Well, I can only speculate, but I think it's because the district attorney simply fears if he were to bring criminal charges against these Native Americans, he would run up against the possibility of what's called jury nullification. A jury can just decide not to convict a defendant if they think the law that the defendant is charged with breaking is, in this case, wrong or misconceived. Something like this happened in the Bernard Goetz case, which is increasingly something New Yorkers don't know about. But Bernard Goetz was a young and unhappy white male who discharged a firearm in a subway when three black males had approached him and asked for money. I forget what the exact exchange was, something like one said, "You have $5 for me?" And he said, "Yes, I have some money for each of you." He pulls out a gun and shoots at them all. He hits one, I think, paralyzing him. The others he does not hit, but of course he's endangering everybody in the subway car. There is no question this guy is guilty of reckless endangerment, but the jury, many of whom were African American, middle aged and elder African American, who at that time, this is in an earlier era, had themselves had unhappy experiences with the criminal elements of their neighborhood. They just didn't convict him, and he was convicted only of a lesser weapons charge. And I bring this up only because it's a pretty clear example of what's called jury nullification. That Goetz was guilty is undeniable, but the jury just declined to say so. And I think, I don't know, the district attorney in Oregon feels something along those lines here, that these are very sympathetic plaintiffs. I'm sorry, defendants. They're plaintiffs in this case, but they would have been defendants in a criminal case. They're very sympathetic, and a jury might well just not convict them. And so he or she does not bring criminal charges. Why then are they protesting against this law? Well, because they were fired from their job. What is their job? As it happens, they're drug counselors. And so there's a sense in which their being fired is understandable. Their supervisor, I will imagine, can say something like, maybe you have a legitimate reason to ingest peyote for religious purposes, but it really disqualifies you from doing this kind of work. I can't have any of my drug counselors be drug users. This is a thing a supervisor could reasonably say. They're not suing to get their jobs back. What they are asking is to get unemployment. And the state, now we're in an unemployment compensation context, says, no, we don't have to give anybody unemployment if they've been fired because they broke the law. And you can see why this is a reasonable thing, a reasonable policy for states to have. As far as I know or would imagine, any state or any unemployment scheme, any unemployment compensation scheme would have a rule like this. So if you're caught shoplifting from your place of business, and let's say they don't want to prosecute you criminally, but they are going to fire you, you don't have a claim to get unemployment insurance because you were fired for reasons that have to do with having broken the law. And that's the position that these Native Americans are in. They say, yes, we were fired because we broke the law, but the law is unconstitutional. This law should have had an exemption for religious use. So we should get our unemployment compensation. If the law is found unconstitutional, then the fact that we were fired for violating it is obviated. It's no longer an obstacle to our getting unemployment compensation. And that's what they're in court for. I mean, there's also a purely symbolic reason. They don't just want their own unemployment compensation. They want this law to be changed to reflect a kind of accommodation to Native American religious beliefs. I mean, obviously, even though they are in many ways a sympathetic minority, I mean, the federal government has a particular mandate to, be mindful of the welfare of Native Americans. There's a very unhappy story here. This is the state of the great Nez Perce retreat, and what was it, Chief Joseph? Horrible, horrible, story in the late 19th century. The Nez Perce really had been terrifically loyal to their side of the treaty, and under pressure from settlers and prospectors, then President Grant was willing to let the American government side of the treaty go. I wouldn't say unenforced, no longer complied with. There's a very unhappy history here. And there's no question, I think, that, if this were prohibition and alcohol were forbidden, Catholics ingesting a certain amount of wine in a mass would face no persecution at all. There'd be, an absolute, unproblematically affirmed exemption for the imbibing of alcoholic beverage in the context of a religious ritual. And the Native Americans can say, yeah, sure, if we were, mainstream white Americans in a Catholic service ingesting wine during Prohibition, there'd be no problem. So why is it that as Native Americans, we are not granted the exemption that we should get for ingesting this drug for religiously motivated reasons? So that's the fundamental, I hope I haven't left anything out. That's the fundamental nature of the facts of the case. But notice, why is this important? Here again, speculation. The court is reviewing a law and wondering whether or not it's constitutional. But notice, if they find it is constitutional, no one goes to jail. I think it might have been different. I mean, Scalia has these very, very interesting arguments for why is constitutional. In fact, Scalia argues famously he's not even going to subject it to strict scrutiny. It's a really wild case in this way. He doesn't even think that the law has to be subjected to strict scrutiny. And this is a kind of scandal, and it's a shot heard around the world. And even Congress notices and passes legislation to have it otherwise in the future. But I can't help but wonder if these Native Americans were facing, say, 6 to 10 years in jail, then I think you'd be very, very careful to be sure you really felt this law was constitutional before finding it so. As it is, all that they're losing if we find this law constitutional is unemployment benefits. It's not nothing, but it's very different than going to jail. And it makes it easier, I think, for the state. It makes it easier for the court to consider this law constitutional when the consequences to the plaintiff here are nowhere nearly like if they were facing jail time. So it's an anomaly. It's a criminal law. It's a law that makes it a criminal offense to do this thing, but no one is facing criminal prosecution. The defendant in a criminal case is not before the court. You just have somebody unhappy, sort of like Sherbert in this way, unhappy not to be getting their unemployment benefits. A very, very different, easier for the state to defend a criminal law when the consequences of finding that law constitutional aren't that somebody goes to jail, which is usually exactly what the consequences of finding a criminal law in good order happen to be. Okay, that's one background point. Here's another, really messy, but it's there. Well, a lot of people don't like to remember this or realize this. It'll happen to some extent in the affirmative action cases, the Seattle school cases, I guess is such a case. Yeah, maybe it is. You may have noticed what's called, in this case, a concurrence. Concurrences are very important in the law, and they happen all the time. Not too many cases that we look at are important divided in this way, but this is one of them, and the affirmative action cases sometimes are too. What does this mean? Well, even though these cases we look at are often, these heavy, weighty, important clashes of principle and abstract norm versus abstract norm, chin stroking conflicts between apparently equally intuitive abstract convictions. In the end, or foremost, and what a court has to decide, not only what principle is right, what argument do I think is right, but who among these parties, the plaintiff or the defendant, is going to win. That's it. That's the fundamental thing. Is the plaintiff or the defendant going to win? And when I put it that way, you should begin to see how it's possible. You and I could agree that the plaintiff wins, but we think so for very different reasons. Okay. You and I could both think that this is the best painting in the exhibition, but for very different reasons. You might think it's unusually faithful representationally. I might think its choice of color is remarkably original, but we both vote to give it the first prize. So it wins the first prize, but there isn't agreement about the standard. You can see how this could happen all the time. We could agree about the winner. I assume this happens all the time in, Olympic events like figure skating. We might both agree that's the one who deserves the gold. But for you, it's because of technical prowess. And for me, it's because of this balletic, expressive, subtlety that we don't normally see in skating. But we both vote to give that skater the gold, so that skater wins. That means sometimes a holding that this side rather than the other side wins can mask a tremendous amount of disagreement about the principle. And that's exactly what happened in the Smith case. Because, since you've read it, I can say it. Scalia wildly, radically argues we're not going to subject this law to strict scrutiny unless this law is wildly irrational, biased, that kind of deal. We're going to give it ordinary deference. And indeed, it's not wildly biased. It's not, I don't bother to read this case in this class anymore, but there is a case in which the city of Hialeah in Florida essentially was harassing the local Santeria and prohibited animal sacrifice, which they use in their rituals. Goats and chickens are sometimes killed in their rituals. And they prohibited in that law any kind of slaughtering of animals. And the court looks at this and says, really? So, hunters in Florida can still go out and try and shoot some game, and butchers can still do these things, but the Santeria can't. I mean, you don't really have a general interest here. This is just a biased law. That's all. And we're going to strike it down even by the most relaxed standard of review. We don't have to get to strict scrutiny. Scalia is arguing that this law will not be subjected to strict scrutiny. And that means, of course, on his view, of course, it's constitutional. Now, the liberals and the conservatives in the case both agree, of course, it should be subjected to strict scrutiny. The difference is some think it'll pass, some think it doesn't. So some think, this Oregon law really isn't pursuing a legitimate interest by the most narrowly tailored means. And there are interesting reasons for thinking this. Again, I guess we'll get into it pretty quickly. And the conservatives think, yeah, let's subject it to strict scrutiny. No problem. The state has an interest that it really can't give an exemption to. And you can imagine how that interest would be characterized. It's not unlike the Yoder case, where those who think it should be subjected to strict scrutiny and it will pass can say, look, the state's just interested in the health of its citizens, and it wants to be able to stop somebody from using this drug, even if they're using it for religious reasons. Doesn't mean they always will. Doesn't mean the state's always going to prosecute people or try and send them to jail, but that it's an illegal thing to do, that the state has this interest in the health of its citizens. This is a legitimate interest that the state has. And obviously, you can't have any exemptions because it doesn't become undangerous for these Native Americans to use this drug. If it's dangerous, it's dangerous. That's the end of it. On the other hand, those who think that when it's subjected to strict scrutiny, it would fail, have a very interesting thing to point to. And I don't know if you noticed it, it's kind of subtle in the cases. There are other states nearby. I guess it's Washington. They don't mention it, but there are other states nearby that have the exemption in their peyote laws that allow religiously motivated use. So it's very hard to argue that you can't do it when other states do it. That's where I think it's Douglas who says the state's interest cannot be abstract or symbolic. Meaning, and he's also pointing to the fact that these guys aren't being subjected to criminal prosecution. So what's the state's interest here, really, if they don't prosecute these people? It's just an abstract or symbolic interest. I used to be very sympathetic to that. I now think, maybe not. Maybe it could be important in a child custody hearing. You might want to be able to bring this up, even if it's religiously motivated. You might think it, cuts against in a, whether we're going to go to sole custody or shared custody. There are all kinds of places where, even though you rarely enforce this law, you still have good reason to have the law. I think statutory rape is such a case. Very rarely is that enforced. Very rarely. I mean, many 17-year-olds have consensual sex with 15-year-olds, and nothing ever happens to anybody, obviously and rightly. But the state can say, yeah, that's right. But once in a while, there'll be a fact pattern and we'll want to do something about it. So we're going to leave the law. Even though we don't usually have an interest in enforcing it, that doesn't mean we shouldn't have the law exactly as it is on the books. We're not going to get into it, but I'm only saying that these things are really slippery, what the state's interest is and whether or not it can have a real interest, even if it rarely acts on that interest, and whether or not it could insist on a non-religious exemption version of the law because of some reasonable interest in the health of its citizens, et cetera, et cetera, et cetera. Not our problem, because the law is never subjected to strict scrutiny. We'll never know. Because, and this gets back to the earlier point about the concurrence, which I never even defined, but a concurrence simply means you agree with the outcome, but for a different reason. When you write a concurring opinion, that means you agree with your colleague's verdict as to who should win, but for a different reason. So those who follow Scalia in holding there will be no strict scrutiny, and those who say there should be strict scrutiny, but the state will win, both find for the state. So, I want to pause for a moment and get you to think about it. Who's agreeing with who here? Where's the real agreement? You might say the dissent, which applies strict scrutiny and thinks the law would fail, a la Yoder, that the state could have an exception. And if it could, then the law fails, because when the test says by the most narrowly tailored means possible, that means if we can think of an alternative law in which these goals are pursued consistent with this exemption, the law that we have without this exemption, this is the Yoder case, is unconstitutional. So you might say the dissent, we'll just say the liberals here, and the non-Scalia like, you might say, okay, they disagree about whether the law passes or doesn't pass strict scrutiny, but they agree about this very fundamental point: the law should be subjected to strict scrutiny. They agree. Whereas the Scaliaites and the conservatives, although they both agree the state should win and the Native Americans lose, you might say, they really disagree about the fundamental issue here. One thinks strict scrutiny is appropriate and the other doesn't. Why are they in agreement? Well, that's right. Why? Because a case isn't about principle. Who's winning this lawsuit? That's why because they both agree the state wins this lawsuit. And so this really, what's the word I want? I'm getting a notice that my connection is unstable, and maybe you're not hearing me, so I'm suddenly getting a little anxious. But this is something that, when you're just finding out about the law, should really give you pause about what these cases do and do not stand for. So in this case, although in this case, Scalia cobbles together a majority to hold that the Oregon law will not be subjected to strict scrutiny. As a matter of fact, the majority of the justices think it should be. That's obvious. It's in the case. It's just that we have a majority of the justices thinking that for different reasons, the state should win. All right, I'm a little nervous about this message, so I'm going to stop and do this again. Take it up again, and this is a good place to stop, because now I want to turn to why Scalia thinks the Oregon law should not be subjected to strict scrutiny, and that's what we're going to do. Actually, no, I'm still ticking, apparently. So I'm going to pause while you digest this point, and then we'll turn to Scalia's reasons. Then we'll I'll say a little bit more about the back and forth between what would have happened if strict scrutiny had been applied. We'll turn to what Congress does, the Religious Freedom Restoration Act, and then how this impacts on the Obamacare litigation in Hobby Lobby. All right, that's it for now. I'll give you more, I hope, very shortly.